All rise. Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning, counsel. We're here for oral argument in case number 1 CACV 21-0339, Brady v. Tempe Life. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side, as you know, will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired, and appellee's counsel may reserve a portion of that time for rebuttal to address only the cross-appeal issues if desired. Also, we have read the briefs and have conferenced this case. Counsel, you may proceed.
Thank you, Your Honor. Hey, police and court. My name is David Abney. I'm here representing the appellants with Kevin Beckwith. I'd like to reserve about 5 minutes for rebuttal. Last week, as you know, my mind spins in strange ways. Last week, I heard that Rosemary Trapp died. She's the second to last of the Von Trapp family. Her brother, Johannes Von Trapp, is the only one left. Which got me thinking about The Sound of Music, of course, but also about families and how much they differ. Apparently the Von Trapps, even though there were about 13 or I forget how many, 12 of them, they got along fairly well. But most big families don't. You get factions and fights. People have lifelong grudges. They split apart. They come back together. And there's always changing dynamics, which made me think very much about this particular case, where you have dissension and dislike among the siblings of the decedent. But when you have a statutory wrongful death action in Arizona, the statutory plaintiff is the one in charge of the case, represents all the statutory beneficiaries, definitely for liability, and in general, if there's not some sort of fundamental dispute among themselves, for damages. In fact, when you think about a wrongful death case, except in the most extreme, strange examples, you really need 4 things. You need duty, breach, approximate cause, and damages. You don't have damages, you don't have a case. So the one in charge of the case really ought to be trying to make sure that damages are at least disclosed enough so the case can move forward to its resolution, whether it's a settlement or a trial. But here, things fell apart because of, I don't know, dislike or whatever it might be. The statutory plaintiff did not maintain contact with all the statutory beneficiaries, did not keep them informed about everything that was going on.
Now, that's Barbara, correct?
Yes.
All right, and she did make an effort to reach out to the beneficiaries who were essentially absent, at least initially, or for a good part, and did not really come forward to assert their claims with regards to individual damages.
Well, it was, and actually she did the initial job of making a disclosure about the damages. It was not the most exciting one I've ever read.
Sort of a blanket disclosure that there may be damages claimed at some point.
I think that's very close. What they said was, for the disclosures, was that the statutory beneficiary is expected to testify regarding his or her relationship with the father and how the father's death has affected him or her, basically it. That's not a lot. But then again,
wasn't there some qualifying language saying if they elect, I mean, there's some language that precedes that seems important.
I don't think it is important. I mean, if they elect, I mean, why wouldn't they elect to have some damages? The only one who didn't, I think, was Patricia, who says, I don't want anything to do with this. But the others never said, we don't elect not to have no damages, and why would they? I mean,
but they came in for the first time in August of 2020 after disclosure and discovery was done.
Right. But then, when you say after, the statutory plaintiff had made the initial disclosures, even though they were bare bones, they had been made for all 3 of what we sometimes call the excluded statutory beneficiaries. So it was there. It was not the best in the world, but it was there. I mean, for wrongful death, when you're talking about a parent and a child, the wrongful death jury instruction, the standard jury instruction, specifically says you can get damages for loss of guidance or loss of companionship.
But going back to the point Judge Thumma raises, the initial part of that statement, that disclosure, that if one of the 3 elected to pursue a claim for damages, they're expected to testify regarding
Right.
the relationship with the father. Doesn't that really tell us that we don't know whether they're going to come forward?
No, what it tells you is the statutory plaintiff is not doing a very good job of drafting and not doing a very good job of protecting the interests of all the statutory beneficiaries. Why would you put that sort of weasel language into a disclosure? I mean, that's just ridiculous.
And
You simply say,
and I understand your point, and there's some questions I have about that as well, but that's what she did.
right, and she shouldn't have done it that way, but I don't think it destroys the disclosure. It just makes it sort of a head scratcher. You look at that and go, well, why did you put that language in there? Because the last part of it says, talks about regarding the relationship and how the death is affected. But you don't need much for wrongful death disclosure when you're talking about loss of a parent. Just loss of companionship is enough.
So you're saying that satisfies Rule 26.1?
Yes,
that one sentence?
just barely, Your Honor, but it's enough. And
So why was there a need to supplement on the August 3rd, 2020 affidavits?
I think the lawyers for the excluded statutory beneficiaries wanted to put a little more oomph into this and help make it clear that there was a loss indeed, which would help in settling the case and maybe ease the whole thing through the system so that there could be a comprehensive global settlement that includes everybody. Now, the jury, in the end,
That's a fair point, but doesn't that sort of undercut your assertion that that's barely enough on the original disclosure? I mean, if what is the intent of 26.1? It's to
provide-
put your cards on the table and
Yes.
allow opportunities to settle, perhaps, prepare for trial,
Right.
prepare for the subsequent litigation.
Well, there's enough there that you could say, okay, these people are saying that there is their relationship with the father and the death is affected. Okay, that's enough. We need to depose these people to find out exactly what their relationship was. Maybe we can argue to the jury there wasn't a good relationship at all. And in fact, maybe they ought to be paying damages to the estate because they were so mean to the father. All kinds of things you can do in a deposition when somebody gives you this sort of basic disclosure. You can flesh it out, but they didn't bother. Of course, they didn't need to because the statutory plaintiff let these poor people have it when she responded to the motion for summary judgment on the damages. They said, well, on the one hand, we represent all the statutory plaintiffs, and we don't want to do anything to hurt them. But by the way, they didn't disclose anything worthwhile. They haven't participated in the case. They haven't done anything at all, which is sort of like taking a gun to your head when you're the statutory plaintiff and saying, they didn't do anything at all, but I'm in charge of the case.
But that's an issue between the statutory plaintiff and these three siblings, correct?
Yes, but it's also an issue that's very important to decide. Why and how could the trial judge say, okay, you're not going to be allowed to present any damages. You're not going to be able to recover any damages. How can you do that when there has been a basic disclosure, and the statute specifically says that the jury shall give such damages as it deems fair and just. The judge took over from the jury. He says, well, I don't
counsel,
think
you're
it's
not
fair and
arguing
just.
let's exclude your clients from this calculus. And Barbara herself provides a disclosure saying, if I elect to pursue damages, I will testify about this, X,
Yes.
Y, and Z. You're not saying that a trial court needs to disregard 26.1 obligations in deference to the statute that you just quoted, are you? I mean, you need to comply with both.
You need to comply with both, but the one that controls in this situation has got to be 12.613. That's the one that's right on point as to who is supposed to be giving the damages. Who has that decision? It's the jury. If the disclosure has somehow been deficient, that's something you can leap on at court in front of the jury and says, look at this disclosure.
So you're saying, let me ask another hypothetical.
Sure.
Statutory wrongful death claim, no disclosure whatsoever. Plaintiff says, I've got the statute. I don't need to comply with your rules, Judge. You're saying that goes to the jury?
No, you need to make some sort of a disclosure. There has to be some sort of foundation, and a disclosure was made. The trouble is, I think you would be confronting a motion for sanctions, not a motion for partial summary judgment, a motion for sanctions for failure to cooperate in discovery, which could result in dismissal from the case. That's a slightly different kettle of fish than the kettle of fish we have here, though.
And I understand, and I was asking a hypothetical, but...
Well, I like hypotheticals.
Well,
That's good, that's fine.
it strikes me that 26.1 has traction here as well as the statute that you quote.
Yes, but we have passed over the hurdle of 26.1 just barely. I mean, so this is like one of those Olympic races where you clear that hurdle just enough, it's teetering and whatnot, but you made it. And that they made it far enough. And then to go on later and say there's been no disclosure, and they haven't cooperated at all, they haven't done anything, and the judge sort of got infected by this, as well, they didn't do anything, and they're trying to take advantage of the wrongful death statute by getting a recovery. Well, that's the point of the wrongful death statute, is to get a recovery, and for liability, they didn't have to do anything at all. In the briefs that we got on appeal, even, the other side kept saying, we were in charge of liability. We're in charge of liability. That's great. Well, then being in charge of liability means moving the case forward for everybody. Every caption that I saw in the index of record, there's about 400 items in the index of record, and a lot of them, some are exhibits and whatnot. But the ones that have a caption, they all say the same thing that, I even wrote it down. It says, estate of Richard F. Brady Sr. by and through its director, Barbara Lance, on behalf of the estate and all statutory beneficiaries. I mean, she was there to represent all of them to the best of her ability. As a fiduciary even, it'd be we have a very high standard of care there. And she didn't do it. She threw them under the wheels, threw them to the wolves, however you want to put it.
But isn't that, and again, and I know your brief focuses a lot on fiduciary obligations
right.
of a statutory beneficiary who presses a claim like Barbara, but there's been no breach of fiduciary claim joined. And to my knowledge, there's no separate breach of fiduciary duty case pending about her actions.
So well, it probably would accrue at the end of the appellate process.
And that's a fair answer, but it's just, I understand your concern about fiduciary duties and their potential breach, but that's not really what we're asked to address here.
Well, let me elucidate, if I may, if I have the capacity to do that. What she did was to say to the court, disclosing confidential communications with the client, they have not communicated with us, they have not done anything, although she was in charge of liability. They don't deserve, and the other side's right, they haven't done anything at all. You didn't need to say that in responding to the motion for summary judgment of damage. You didn't need to say that at all. That is really a disservice. That is a breach of fiduciary duty.
And I understand your point.
And that's bad because it confused the trial judge, and the trial judge comes up with this I've never seen before kind of order saying, no, you don't get to present any damages evidence at all, and you're not going to be able to assert any claim for damages at all.
Isn't that, though, what happens, and let's take it out of the wrongful death context, but when someone fails, demonstrably fails, not perhaps arguably fails, to provide proper damages disclosures under 26.1, and damages are a necessary element of the claim, like a common law negligence claim, doesn't the case end there?
It can. The only reason I say it can is there's this strange case, and I wish I could, and I put it in my brief somewhere, I can't remember the name, but it said you don't have to have damages in a wrongful death case. And I've always scratched my head over that, but that's what the case says. You don't actually have to have damages in a wrongful death case. This case could have proceeded forward. Yeah, I don't know if that's on point or not, but I'm always struck by that case. But here there was enough to say to the jury, to the judge, look, there is a disclosure here. It's not a great disclosure, but it's there. It's on the record, and it's enough to get us past this point where. And by the way, why not let them do some supplemental disclosure on this? It's not going to prejudice anybody at that stage. That I could see.
Well, trial was coming up, right? August, we've got a trial in November that actually happened. I mean, it wasn't one of these that got sort of kicked down the curb.
Well, actually, it would have given the defense a grand opportunity. They could take whatever new disclosure is and just rip these people to pieces if they wanted to, if they're good lawyers, Perry Mason-style cross-exam.
Understand, but those 120 days before trial are precious, right? I mean, there's a lot of stuff going on.
It is precious indeed, but it was also disastrous for these poor people because they're banished from the case, which is not how it's supposed to be. There was a point earlier.
Isn't that a little bit harsh words when you sit back and don't do anything for 2 years?
They're allowed to sit back and not do a thing on liability, right? They don't have to do anything on liability.
Yeah.
Because the statute damages. Well, to say that they weren't doing anything on damages, there was a disclosure done on their behalf, as should have been done by the statutory plaintiff. It wasn't the greatest
Did they have
piece
some
of work.
input on that?
Pardon me?
Did they have any input on that one sentence?
Not that I know of. But then again, they did. I mean, imagine this is your case as a lawyer. You've got these clients that you have not had much contact with at all. You put something bare bones in there. They've lost companionship and guidance of their father, period. And that's 100% accurate. That's 100% fair. Because there's no way, unless you believe in spiritual unless you believe, I don't want to step on anybody's religious feelings, unless you believe you can communicate across the void, you've lost that companionship and guidance forever. And you can certainly say that this particular plaintiff has lost the companionship and guidance of the deceased father. There's no question that is a proper, good, valid disclosure. This comes awfully close to that. I would, anybody here on the bench, or, you could have done better.
I go back to the point I made originally. This disclosure, what we're calling a disclosure, is really sort of a placeholder conditioned on them coming forward. I mean, it doesn't say that they will, in effect, testify regarding their relationship with their father. It says if they elect to pursue a claim for damages.
Right.
I mean, that is conditional.
Well, if they show up at trial and say hi, and of course, remember, the statutory plaintiff listed them as witnesses. So if they're called to at trial, as one would expect from being listed as witnesses.
No, not if they're called to testify at trial, if they pursue a claim for damages.
Right, which is, well, their point of pursuing the claim of damages would be to appear at trial and testify, I do have damages, or to appear at a deposition if they were called to that, I do have damages. Which leads to that one other point, a very related point. What do you do when you have a client that's not communicating with you? You hunt them down. If it's your client, and these people were their clients, no question on liability purposes, they were the clients throughout this case. You find them. You can do a skip trace, you do whatever you have to, and maintain contact, and you send them every piece of paper.
But isn't that all over here with the statutory plaintiff? What does that have to do with them, the appellees?
Well, they're the statutory plaintiff and the estate. It goes to their duty, their fiduciary duty, and one of that is to maintain contact with your client. You have to do it. You have to go, and we've all had this experience as lawyers. You can't find Joe Blow or Jane Smith, and they're your client, and you're desperate. You've got to get a hold of them. That happens to insurance lawyers all the time. And they do skip traces. Good lawyers find these clients, they maintain contact. At the very least, they send documents, return receipt requested, and they keep doing it and keep doing it, even though it's a pain. You still have to do it because they're your client. And throughout this, the statutory plaintiff had these people as her clients.
Counsel, let me ask you, though, and that comes back to a refrain that I've tried to press on fiduciary duty. Let me ask you a hypothetical. A statutory plaintiff does not keep in contact with a sibling, and that constitutes a breach of fiduciary duty. And again, I'm asking you a hypothetical. What is the remedy? Isn't that called a separate breach of fiduciary duty claim as opposed to, unraveling a decision or a settlement in a case?
Well, I don't think it's A or B. I think it can be A and B. Maybe there's a claim for breach of fiduciary duty that could be pursued later. But also, it matters in this case because the statutory plaintiff complained quite visibly and vocally to the trial court. These people are not cooperating, they're not doing anything, they haven't done anything, although I'm in charge of the case, but they haven't done anything, and the implication is they're bad. Why would you want any people this bad to get any kind of damages? And the trial court, very smart guy, Tim Thomason, I used to practice with him, very, very smart. He bid on this, and unfortunately it failed to enforce the plain terms of 612 and 613. I'd like to reserve 2 minutes and
All right.
counting. Thank you, Your Honor. Unless there's a further question, which I didn't think so. Okay.
Good morning, Your Honors. My name is John Breslow. I represent the estate of Richard Brady. Barbara Blanche, who is the personal representative of that estate and also a statutory beneficiary, and her brother, Patrick Brady. I'm going to take about 6 minutes of the time for appellees, and then Hospice of the Valley and Tempe Friendship Village are going to split the remaining 14 minutes. I think the panel's inclination is correct that this case took sort of an odd turn into this land of breach of fiduciary duty. But more problematic than that is that detour is predicated on three falsehoods. The first of the falsehoods is that the alleged excluded statutory beneficiaries did not receive notice. And of course, they did receive notice. They received a thorough notice that explained to them their rights, what they needed to do, the fact that there was a conflict and they couldn't be represented by the statutory beneficiary, and they stated in their brief that they did not receive notice, and then we point out, well, their own attorney told the court that they had notice of the litigation, and their own attorney told the court they didn't do anything in response to the notice. And then, of course, we have the three returned certified receipts that came back. So the statutory beneficiary and plaintiff fulfilled her obligations to contact all these people. The second incorrect statement that is troubling is the suggestion that all of the claims were settled in this case, and that is entirely not true. The final judgment, which is in the record at 399, specifically carves out their claims. Their claims were not affected at all by the settlement. And to suggest otherwise is just simply an attempt to make this the facts of Wilmot, which was an egregious set of facts, which every lawyer in my position since then reads 10 times a year to make sure we're in compliance with Wilmot. And Wilmot specifically tells us that separate settlements can be made so long as the other statutory beneficiaries' rights are not prejudiced. And so that was followed. And the third thing that's troubling is the suggestion that, well, there really isn't a conflict between statutory beneficiaries. And so Barbara could represent, and through her attorneys, could represent all of these family members. And that simply is not the law. All three of the cases that we rely on, Nunez, Balder, and Wilmot, all say very specifically that there are situations in which a statutory beneficiary can, and their attorneys cannot represent all of the other statutory beneficiaries. It's in every single one of those cases. And it's in every single one of those cases for a reason, and it's because it's true. And it was no more true than the facts in this case where you had the two statutory beneficiaries that we represented that were beneficiaries of the will. And you had one child who had stolen his father's identity and had gone to prison for it. And so you can see the conflict that could arise in that situation. If he had been our client and we said, look, you really don't have a consortium claim. I mean, you went to prison for stealing your dad's identity. Maybe what your better avenue is to contest the will that you were excluded from and proceed as a beneficiary under the estate where there will be no judgment as to your particular conduct. Well, that would have put us in conflict with the two statutory beneficiaries that were beneficiaries under the will. So this case in spades describes a situation where there is, in fact, a conflict, and all three of those cases recognize that.
And counsel, the conflict is with respect to damages, correct?
Correct.
Yeah,
correct.
not liability.
Not liability. And that arises in our practice all the time where we zealously, we took this case all the way through trial. I mean, we filed a brief in support of their claim on appeal on the issue of liability. And that's the cross appeal, which I'm not going to address because our brief is an amicus, but we filed that to protect the issue of liability on appeal. So we have zealously represented the issue of liability. We couldn't do it on damages. We notified them. They acknowledged that they got the notification. And then when we filed that brief to the trial court, it was simply, number one, they were represented by counsel at that point in time, so there can be no argument that their rights were somehow prejudiced. But we had to set the record straight. We had to defend the interests of our client who was under attack for this claim of fiduciary duty, which, quite frankly, they never even needed to make. I mean, I'm personally somewhat persuaded by the argument that the disclosure was adequate with respect to, hey, if they come forward and testify, they're going to testify in these categories. I mean, we didn't brief that issue, and I'm not going to address it. But
your clients took a somewhat different position in front of the trial court, though, on the summary judgment briefing on that specific issue.
Well, we didn't say they cannot come forward and assert a claim. We just set the record straight as to what had occurred prior to that time, because The suggestion was that our client, Barbara Blance, had done something improper. And here's
Understand.
everything that our client has done.
Understand.
And it was factually true that no one had come forward in 2 years after receiving certified letters saying, here are your rights. So I don't think there was anything improper at that point in time, and they had counsel at that point in time. If there was something factually inaccurate about anything that we had said, they could contest it at that point in time. With that, I'm going to pass on to the other counsel unless there are any other questions.
Thank you, counsel.
Thank you.
Good morning. May it please the court, I'm Bruce Smith on behalf of Appalachia Tempe Life Care Village. The Bradys are asking this court to reverse a trial judge who followed the rules. Pre-trial schedules were in place, and Judge Thomason in 2020 was consistent with all of the parties that he had deadlines and he was going to enforce them. We tried to extend deadlines earlier in the year. He gave us a discovery deposition deadline of the end of May. We had COVID issues. We were trying to take in-person depositions of experts. Judge Thomason said, you can try, but if you can't get it done, you're going to have to do the Zoom deposition route, which we did. He gave us until the end of June. He was not going to extend the discovery deadlines for Barbara Blance and Patrick, Hospice of the Valley, or my client Friendship Village. He stuck to those deadlines, and that is the absolute right of a trial judge to do. And in this case, we filed our motion for summary judgment on the absolute last day to do so. Our motion was clear. They haven't entered the case. And we knew from the outset that there was a conflict of interest. And any lawyer who is dealing with an opponent and that opponent says, I have a conflict of interest, I believe that the lawyer has to take his opponent at their word. There was a conflict, and the rules say when there is a conflict in a wrongful death case, those other statutory beneficiaries have to make their interest known. They received notice and they didn't do anything for 2 years. And so when we filed the motions, then we started hearing rumblings. What's going on in the case? And we went to Judge Thomason and said, there are rumblings about these people coming in. And he said, they haven't come in yet. I'm not going to open discovery in this case. Again, consistency in his pretrial schedule. Then they filed an opposition to the motion for summary judgment, and then they submitted a disclosure statement. The court has asked whether the disclosure statement that was submitted by Mr. Solomon was adequate. It was not. Rule 26.1 clearly says a party has to disclose the substance of their testimony. What in that disclosure statement from Mr. Solomon said that Richard Brady Jr. is going to testify regarding the guidance that he received from his father in the last 10 years of his life?
Did the declarations that were submitted about that same time instruct that disclosure?
I still don't think so, because some of them talked about, well, maybe I could have had a claim, maybe my relationship with my father could have been renewed. But the issue in a wrongful death case is, what did the beneficiary lose from their father? What was Mr. Brady Sr. giving to his kids? What companionship, what guidance, what love, what affection? That is the loss. What is Dad no longer giving to me? And that was not part of any of their disclosure in this case. And what Judge Thomason did in considering all of this is he applied Rule 16C and 26.1F. Both of those rules say if there is a missed deadline, you have to file a motion and you have to show good cause. They never attempted to show good cause. They still have never had any explanation as to what they did for 2 years. So Judge Thomason followed the rules. He said there is no good cause, and he said there is no prejudice. And when you have a ruling about disclosure, and there was questions about what the sanction is, Rule 37C says the sanction for late disclosure is excluding evidence at trial, in pretrial hearings, and in motions. And the Wong case and the numerous federal cases that we have cited all stand for the proposition that when court deadlines are missed and motions are filed, things that you file in your opposition that are after a deadline, they get stricken from the record. And the Wong decision says it better than any. Deadlines have to be enforced. The only way to enforce deadlines is to put teeth into them, and you put teeth into our pretrial deadlines by excluding evidence that was not properly filed. And that's exactly what Judge Thomason did. You didn't explain why you took 2 years to enter this case. There is prejudice. There's prejudice to the parties. There's prejudice actually to the court, and that is something that cannot be understated. The courts have their own separate interest in keeping cases moving and keeping to the pretrial deadlines. With regard, I would like to just touch on a couple of points. In the reply brief, one of the things that the Bradys requested was a remand for a trial on damages only. The court can take their statement in their reply brief as a judicial admission. That's the relief that they want. If that's the relief that they're seeking from this court, the court can dismiss the appeal as to Friendship Village. We never went to trial. There was no finding of liability or causation on our part. So if there is a remand on damages only, it's not Friendship Village, and the case should be affirmed for our dismissal. Thank you, Your Honor.
May it please the court. My name is Brian Imbornoni. I represent Hospice of the Valley. I would like to start with the issues raised in the appeal brought by the Bradys and then spend a few minutes on the cross appeal. The trial court's summary judgment excluding the Bradys should be affirmed. While the grant of summary judgment is reviewed de novo, all of the trial court's predicate rulings regarding discovery, the disclosure rules, and the enforcement of pretrial deadlines are reviewed for abuse of discretion. Turning to those predicate rulings, the trial court did not abuse its discretion in finding the Bradys' initial damage disclosures inadequate to go to the jury. In their briefs, the Bradys described their disclosures as short, minimalistic, bare bones, skimpy, pro forma, streamlined, shorthand. They were all of those things. They were also inadequate because they disclosed nothing about the relationship between the Bradys and their father, and because they were conditional, as Judges Thuma and Cruz have noted. They did not disclose whether the Bradys were even pursuing claims. The trial court also acted within its discretion to reject the Bradys' later disclosures. The court found that they did not disclose any relationship between the Bradys and their father. The court also found that the Bradys' affidavits offered no justification for the late disclosure. As Mr. Smith's comments reflect, and as the record in this case reflects, Judge Thomason runs a tight ship. He set a firm trial date, and he held the parties to it. He expected the parties to follow the rules and to obey his orders, and that was within his discretion. Turning to the fiduciary duty issues, the Bradys asked this court to try a breach of fiduciary duty claim ab initio in this court, and the PR joins in the request that this court enter some kind of advisory opinion on this. It is HOV's position that this issue was not preserved below. It is a collateral issue that has no bearing on whether the court affirms the summary judgment. If the court is inclined to reach the fiduciary duty issue, it's the PR's view that, it is Hospice of the Valley's view that the PR did things by the book. The PR's counsel decided he had a conflict of interest. That was a reasonable decision because the siblings had conflicting views of the facts, and Barbara and Patrick had differing interests as beneficiaries under the will. The PR gave reasonable notice to the siblings that they needed to take action, Wilmot by the book. But the court doesn't need to reach the fiduciary duty issue. Even if the PR breached her fiduciary duty, that provides no relief from the entry of summary judgment. As an example, if the PR breached her fiduciary duty by missing the statute of limitations, that would provide no grounds for relief against the defendants. The law imposes certain obligations on the parties to preserve and present their claims. A would-be plaintiff needs to file the right pleadings in the right court at the right time. The party needs to appear, follow the rules, follow the orders. If that doesn't happen, that's not the defendant's problem, that's not the defendant's responsibility. At the end of the day, if the plaintiff breached a fiduciary duty owed to her siblings, and we don't think she did, the Brady's claims are against the fiduciary, as Judge Cruz noted. Those are claims that need to be brought in a court of original jurisdiction. In conclusion, Judge Thomas's decision to preclude the Brady's from presenting damage claims was not abuse of discretion, and his summary judgment ruling should be affirmed. Turning to the cross appeal, the Hospice of the Valley's cross appeal does not affect the claims of Barbara Blance or Patrick Brady. The jury's damage awards in favor of those plaintiffs have been satisfied and settled. The point of the cross appeal is that if the court were to reverse the summary judgment entered against the Brady's, those claims are nevertheless barred because the PR failed to prove that Hospice of the Valley's negligence was the proximate cause of Mr. Brady's fall. This was raised by a Rule 50 motion, so the review is de novo. Just a very few facts. Mr. Brady was admitted on March 15, 2017 to Friendship Village. The following day, Mr. Brady was assessed by hospice case manager Ed Hartman, RN, and nurse practitioner Melissa Bush. 15 minutes after they left, Mr. Brady was escorted to lunch by Friendship Village Assistant Activities Director Joey Arnold and fell. The PR's principal theory was that Hartman and Bush were required to tell Friendship Village nursing staff that Mr. Brady required both a walker and maximum hands-on assistance. On the evidence presented, a reasonable jury could not find, without speculation, that the failure to give that instruction was the proximate cause of Mr. Brady's fall. The record shows that the Friendship Village nurses were already told this information. They had done their own assessment and documented the need for a walker and assistance. More importantly, there was no evidence that if Hospice of the Valley had provided an additional warning, that this information would have been communicated to Joey Arnold within the 15 minutes between the time that the HOV personnel left and the time of the fall. To the contrary, there was evidence that this would not have been communicated because Joey Arnold was not part of the medical staff. The PR's fallback is HOV should have seen the cane in the room and replaced it with the walker. But there was no expert testimony that if that request for a walker had been made, it would have been delivered to the room within 15 minutes within a reasonable medical probability. And that argument also fails because the PR's causation expert insisted that Mr. Brady required both a walker and hands-on assistance to avoid the fall. I see that I'm out of time. Thank you, Your Honors.
Thank you, counsel.
Just a couple of points. As far as the falsehoods that came up at the beginning of their responsive argument, The first supposed falsehood was that there was receipt of notice. There was notice that was attempted to be sent and partially successfully sent at the very beginning, and after that there was no contact, no notice of deadlines, no forwarding of documents, no nothing. They simply gave up on trying to contact these people.
I'm sorry,
for almost 2
are you
years.
saying that there was no receipt of notice initially, or just no subsequent attempts to
For
contact?
some of them, there was no receipt of notice, but there was no subsequent, you file something, you send it. You file something, you say, you get something, you send it. There was none of that. The normal flow between client and attorney, between attorney and client. They say, well, the final judgment didn't really resolve everything, and that the excluded statutory beneficiaries' rights were not affected. The last sentence of the final judgment says, final judgment as to all claims and parties hereby is entered pursuant to Arizona Rule of Civil Procedure 54C. That wrapped up everything and slammed the door on the excluded statutory beneficiaries. They say there was a conflict on the, I assume that the full idea is there was no conflict on damages. There was a conflict on damages among the statutory beneficiaries, but was there? I mean, every statutory beneficiary wanted to get a maximum recovery. That was it. A jury may have looked at the excluded statutory beneficiaries and examined their testimony and said, well, you know, you didn't have much of a relationship. We're going to give you nominal damages or no damages at all. We will never know because they didn't get the chance at trial to present whatever they wanted to present as far as the damages. There was a settlement with Tempe Life Care. We don't know what it was. Under Wilmot, my clients had a right to find out what the terms of that settlement were and the amount of the settlement, never disclosed.
Does Wilmot, the settlement wasn't for your clients though, right?
It was for some of the statutory
For
beneficiaries.
two, Barbara and Patrick, right?
Yeah.
And expressly, at least the judgment expressly carved out your clients from that
But
settlement.
they have a right as statutory beneficiaries under Wilmot to know the terms of any settlement. They never found out. I think I asked the court if you could order that be disclosed, and you might want to put that in your decision.
And Wilmot addressed a across-the-board settlement
Right.
that the court was asked to approve.
In that particular case, but the language was very strong about it. If there's a settlement agreement, you need to disclose it to all the statutory beneficiaries, which makes sense.
In Wilmot in
because-
particular, because it was their claims.
Yes, but it also makes sense because the statutory beneficiary has a duty to represent all of the statutory beneficiaries. Yeah, statutory plaintiff has a duty to represent all the statutory beneficiaries.
It's fair to say, though, your clients received no proceeds from that settlement. Wouldn't you agree with that? The record
Yes.
Okay.
We have no clue what the settlement was.
All right.
And thank you very much for your patience and time. I appreciate it.
Thank you, counsel.
Thank you. Thank you.
We thank you for your preparation for your presentations today, and the matter is taken under advisement, and we will issue a written decision in due course. We're at recess.